An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman.
Section 5 of the 14th Amendment. City of Boerne versus Flores, 1997. United States versus Morrison, 2000. Board of Trustees of the University of Alabama versus Garrett, 2001. And Nevada Department of Human Resources versus Hibbs, 2003.
The 14th Amendment was ratified in 1868, more than 7 decades after the 11th Amendment was ratified. Section 5 of the 14th Amendment gave Congress an important new enumerated power. Quote, "The Congress shall have power to enforce, by appropriate legislation, the provisions of this article." Because it was enacted later, the Supreme Court has found that Section 5 gives Congress the authority to override or abrogate a state's sovereign immunity that it held in Hans versus Louisiana was presupposed by the 11th Amendment. But how much of a state's sovereign immunity can be abrogated depends on the scope of the 14th Amendment. Study guide. Do you see any parallel between the phrase, quote, "appropriate legislation" in Section 5 and the necessary and proper clause of Article 1? What are the, quote, "provisions" of this article? That phrase refers back to Sections 1 through 4 of the 14th Amendment. Section 1 contains the now famous Due Process Clause. Quote, "Nor shall any state deprive any person of life, liberty, or property without due process of law." If a state deprives a person of liberty without due process of law, Congress has the power to enact appropriate legislation to enforce that person's civil rights. In 1940, the Supreme Court held that the phrase liberty in the Due Process Clause embraces the First Amendment's Free Exercise Clause, which provides that, quote, "Congress shall make no law prohibiting the free exercise of religion." The idea that the Due Process Clause in Section 1 of the 14th Amendment protects rights enumerated in the first 8 amendments is now known as the Incorporation Doctrine. Study guide. Can you see how expanding the scope of Section 1 of the 14th Amendment affects the scope of Section 5? To understand the interaction between the First and 14th Amendments, follow this sequence. First, if a state deprives a person of a liberty the court is deemed to be fundamental, such as the free exercise of religion in the First Amendment, then, second, Congress has the power under Section 5 to enact, quote, "appropriate legislation to enforce." Third, the right to the free exercise of religion. But what does it mean for Congress to enforce the First Amendment with appropriate legislation? In Katzenbach versus Morgan, the Supreme Court held that Section 5 gives Congress the power to, quote, "remedy or prevent unconstitutional actions." However, and this is crucial, City of Boerne versus Flores held that Section 5 does not give Congress the power to make a substantive change to the Supreme Court's interpretation of the scope of Section 1. To understand the outcome of Boerne, therefore, we will have to study a brief history of the Free Exercise Clause. In Sherbert versus Werner, 1963, the Supreme Court held that because of the First Amendment, a law cannot substantially burden the free exercise of religion without showing a compelling interest for doing so. Nearly 3 decades later, in Employment Division versus Smith, 1990, the court changed course and held that a state need not show a compelling interest for substantially burdening the free exercise of religion if the law is, quote, "neutral towards religion." A law is neutral if it imposes the same burden on all faiths. Smith proved to be very unpopular among both Democrats and Republicans. In 1993, Congress, which was then controlled by the Democrats, used its Section 5 powers to enact the Religious Freedom Restoration Act, or RFRA. The House passed RFRA unanimously. In the Senate, the vote was 97-3. President Clinton signed RFRA. As its name suggests, RFRA sought to restore Sherbert's more protective test. Like Sherbert, under RFRA, states could not substantially burden the free exercise of religion unless they can show a compelling interest for doing so. After RFRA was enacted, the city of Boerne, Texas denied a building permit to St. Peter's Catholic Church. In response, Archbishop Flores sued the city in federal court for violating RFRA. He claimed the denial of the building permit substantially burdened his free exercise of religion without a compelling interest for doing so. Study guide. Could Congress require Texas to comply with the First Amendment standard that went above and beyond what Employment Division v. Smith required? The Supreme Court held that Congress lacked this power. Justice Kennedy, writing for the Flores Court, found that Congress's enforcement powers under Section 5 could only remedy constitutional violations of Section 1, as Section 1 had been interpreted by the Supreme Court. Section 5 does not give Congress the power to decree the substance of the 14th Amendment's restrictions on the states. In other words, once the court has defined the substance of Section 1, as it did in Smith, Congress cannot use its Section 5 enforcement powers to expand or contract that scope. Congress may only remedy violations of Section 1 as it has been defined by the court. Study guide. How does the court draw the line between remedial legislation and substantive legislation? To assess whether Congress has gone beyond its remedial power, the court measures the fit between the injury to be prevented and the means adopted to that end. Specifically, that fit must be congruent and proportional. Justice Kennedy explained, there must be a congruence and proportionality between the injury to be prevented or remedied and the means adopted to that end. Lacking such a connection, legislation may become substantive in operation and effect. Let's now apply this framework to RFRA. What is the injury Congress attempted to prevent? A state law that substantially burdens the free exercise of religion, which is protected by Section 1 of the 14th Amendment. What are the means Congress adopted to prevent such a violation of Section 1? When sued by a citizen, the state must show a compelling interest justifying the burden. Is the fit between the means and the ends congruent and proportional? The Supreme Court answers no. Smith already held that the state need not show a compelling interest to justify burden on free exercise if that burden was imposed by a neutral law. Because the court found RFRA to be beyond the substance of Section 1 as defined by the court and was not remedial legislation, Congress lacked the power to enact it under its Section 5 powers. While the court held that Congress was free to limit its own powers, RFRA was unconstitutional as applied to the states. Justice Kennedy explained,
when the court has interpreted the Constitution, it has acted within the province of the judicial branch, which embraces the duty to say what the law is. But as the provisions of the federal statute here invoked are beyond congressional authority, it is this court's precedent, not RFRA, which must control.
Over the next decade, the Supreme Court would consider 3 other federal laws in which Congress purported to use its Section 5 powers to override or abrogate state sovereign immunity. First, in United States v. Morrison, 2000, the court held that a state could not be sued for violating the Violence Against Women Act, VAWA. Congress lacked the power under the 14th Amendment to create a federal civil cause of action for gender-motivated violence. Second, in Board of Trustees of University of Alabama v. Garrett, 2001, the court held that a state cannot be sued for money damages in federal court for violating the Americans with Disabilities Act, ADA. However, the third case changed course. Over the prior decade, Chief Justice Rehnquist had consistently voted to uphold state sovereign immunity. But in Nevada Department of Human Resources v. Hibbs, 2003, he found that Congress could abrogate a state's sovereign immunity for purposes of the Family Medical Leave Act, or FMLA. Chief Justice Rehnquist explained why FMLA was different. Quote, unlike the statute at issue in City of Boerne and Garrett, which apply broadly to every aspect of state employers' operations, the FMLA is narrowly targeted at the fault line between work and family, precisely where sex-based overgeneralization has been and remains strongest, and affects only one aspect of the employment relationship.
When it enacted the Act, Congress had before it significant evidence of sex discrimination by the states with respect to the administration of leave benefits.
Further, unlike with RFRA and VAWA, Chief Justice Rehnquist found that when FMLA was enacted, quote,
Congress had before it significant evidence of sex discrimination by the states with respect to the administration of leave benefits. This evidence is sufficiently weighty to justify the enactment of the prophylactic Section 5 legislation, and the Act's family care provision is congruent and proportional to the targeted violation.
Justice Kennedy dissented. He found that with FMLA, quote, Congress was not responding with a congruent and proportional remedy to a perceived course of unconstitutional conduct. Instead, it enacted a substantive entitlement program of its own. Study guide. Can Nevada Department of Human Resources versus Hibbs be reconciled with Boerne? Justice Ginsburg has hinted that Chief Justice Rehnquist joined the majority in Hibbs due to, quote, life experience. His daughter was a recently divorced single mother with a demanding career.